Welcome to the lecture on Chapter 5, Managing Employee Relations. This week, of course, we're going to talk about employee relations. Let's talk about the difference between employee relations and labor relations. Labor relations is usually pretty specific to unions, and that's the employer working with the unions. We call that labor relations. Employee relations is broader than that, whether a company has a union or part of its workforce is part of a union. Employee relations is the bigger picture, which includes labor relations, but it includes other relations with employees who are not necessarily part of a union. So the reading assignment from the chapter this week, there are not a lot of pages that I asked you to read because a lot of the textbook talks about unions in the United Kingdom or Europe, which are a little bit different and have different rules than the United States. So I didn't want you to have to read all that and get confused. Today I'm going to go over some of the basics of unions and union laws here in the United States. The most important of which is the National Labor Relations Act. Sorry to back up real quick though. I had other articles that I asked you to read as part of the reading assignment this week that will actually go through the history of unions in the U.S., which is very interesting. The articles are not that short, but they help you at least understand the reasons why unions came about in the U.S. and as part of the Industrial Revolution. Very good reading to help understand unions. If you work for an employer that has unions, you no doubt have a good understanding of how complex unions can be and sometimes how difficult they can be to work with. So the National Labor Relations Act, that's what governs the relationships between most employers and unions. It doesn't cover certain industries, airlines, railroads, agriculture, government agencies, and small businesses. However, there are other laws that may apply to those different industries. The crux of the National Labor Relations Act is really Section 7, which lays forth the different rights that employees have. They have the right to engage in what we call concerted activity for the mutual aid and protection. They have protection to form, join, or assist unions, bargain collectively over wages, hours, and working conditions, and refrain from any of these activities. So concerted activity, let's go through some examples of that. That's basically for them to be able to get together with other employees and talk about their working conditions, their pay, and so on and so forth. So if a union were to strike, that would be considered concerted activity, and they have a right to do that. If an employee speaks to management on behalf of other employees, that's also considered concerted activity. And then when you have two or more employees discussing their pay or working conditions at work, discussing your pay or working conditions is considered concerted activity. Lastly, if there's an individual that does something that's intended to incite a group to a call to action for everybody to stand up for their rights, that would also be considered concerted activity. Now, you have an assignment this week that you need to complete, and it's talking about unions. These next few slides I am trying to highlight for you because they will be important for that assignment. Union activity, we're going to talk about how employees usually come about being represented by unions. Union activity usually starts with employee dissatisfaction over pay, benefits, job security, or management. To help prevent union organization, employers should do the following. The next 4 slides, we're going to go over different things that employers can do to prevent union representation. Union representation, some people will agree or disagree with me whether that's a good thing or a bad thing. Whether you believe one or the other, it doesn't matter. It does create a lot of extra work and cost for the employer. And a lot of employers would prefer to prevent unions than rather have to deal with unions. And in order to do so, you got to have happy employees so you can maintain, these are the bullet points we're going to go through. Maintain competitive pay and benefits. Ensure that supervisors are effective and communicate well with employees they supervise. They must be good listeners as well as good communicators to the employees so that they are satisfied with their job. It's good to maintain an open door policy so that employees may bring issues to HR and senior management and feel that their voice is being heard. They should consider implementing seniority system if it's common in the industry. I know a lot of warehousing clients that I have that don't have unions. They don't want to have unions, but they will implement union-like systems that include seniority so that employees can work their way up in the company and feel that they have satisfaction as well as job security. Next bullet point, without voiding your at-will status, maintain an environment in which employees do not unnecessarily fear for their job security, that they feel they are fairly treated and that the most qualified candidates are promoted. So that's the notion of fairness and security. If they feel like they work hard and do good, that they'll have a job, that'll help prevent unions from stepping in and trying to represent the workforce. Lastly, if you have disgruntled employees, you need to move them out of the organization. Unhappy employees tend to share their unhappiness with others. But be careful, if they're talking to others about their working conditions and their pay, you don't want it to look like retaliation if you try to get rid of those employees. I had a recent situation where an employer had over 100 employees at one particular job site, and there was a couple bad apples that were really poisoning the well, making it hard for the organization to make changes that it wanted to make, as well as to, instigate a better, more productive work environment. And after trying several things, the organization literally, as a last-ditch effort, just decided to let those bad apples go. They hadn't engaged in any concerted activity. They just always pushed back whenever the organization tried to implement new initiatives or try to change things for the better. These group of individuals were always there to complain about it and to resist the change. Ultimately, the organization decided that the only way that they could move forward is to get rid of all those people, which was really hard because a lot of them were higher up, people that had been with the organization for a long time. But it's been about 3 or 4 months now, and let me tell you how much happier they are and how much more progress they've made in the last 3 or 4 months as opposed to the last 3 or 4 years, just because they were able to get rid of those disgruntled employees and move them out of the organization. So push comes to shove, that's kind of a last-ditch effort, but it is important if you want to maintain good employee relations. So if a union is elected in your organization, or you join an organization that has a union, that's fine, you can deal with it. But employers must bargain in good faith, and that's talking about wages, hours, working conditions. A lot of times a union will have a collective bargaining agreement that they sign with the company, and the collective bargaining agreement will set forth these terms in terms of wages, hours, working conditions. A lot of times the CBA, the initial term is like 3 to 5 years, and then the employer and the union will renegotiate it every year or so with those terms. So a lot of times they may be small changes, sometimes there'll be significant changes. It just depends on how aggressive the union tries to be. You must provide union with information regarding bargaining subjects. That includes financial information of the company. Neither side is required to agree to any proposals in terms of bargaining, but you must do it in good faith. That it tends to sometimes be a joke because a lot of times, I don't want to mischaracterize all unions, but I've seen it many times before where the unions do not try to negotiate in good faith. Both sides must bargain to impasse before taking action. So you must exhaust all bargaining avenues before considering an impasse and going on strike or lockout for the employer. In terms of union security, union and employer cannot agree that all bargaining unit employees must be members of the union, but employees may be required to pay costs of union representation except in right-to-work states. So you may have seen that in the news here and there, but there has been a lot of scuttlebutt around about being a right-to-work state, which basically says if I don't want to pay a union due and be a part of a union, I shouldn't have to. And states that do consider themselves right-to-work states do give that decision to the employer to do that. There's been some big cases as well that have gone to the United States Supreme Court dealing with public employers and whether an employee of the government has a right to work and to refuse being part of a union or paying union dues. And then strikes don't happen too often, but when they do, they can be pretty significant. What happens if a union strikes? The right to strike over wages, hours, and working conditions, we call those economic strikes, that's protected. You can't fire the strikers for doing that, but you can replace them. In contrast, when the strike is over some alleged unfair labor practices, the strikers must be reinstated to their jobs at the end of the strike. And of course, as you can imagine, a lot of times if union employees go on strike, they will try to make it an unfair labor, at least allege unfair labor practices, so that they can argue that they should be reinstated at the end of the strike. The union may not engage in secondary boycotting, which is picketing another company to try and prevent it from doing business with the company that they're striking against. However, they may engage in handbilling and picketing to inform customers of a business of a dispute within a supplier of that business. The picketers may not engage in mass picketing to prevent ingress or egress, violence or threats of violence. In some states, picketing and handbilling may occur in private property, right outside a retail store and other businesses. So let me go through this and tell you some quick stories, and then we'll end the lecture for Chapter 5. I've done a fair amount of union work. I did have one where it was this very example where it was handbilling and picketing the customers of a business. So the company that I represented had truck drivers who were part of a union that went on strike, and they went to their customers' locations, which was a famous fast food restaurant, and tried to say that that they're a bad organization, that they do business with trucking companies who underpay their employees, and then they tried to smear them with pictures of cockroaches in the food and other kind of outlandish allegations to try and gain leverage against the company to negotiate in more favorable terms to the union. And in our instance, we felt that they were crossing the line. They were blocking the entrance and exits so that customers could not get in. We were literally secretly filming them, taking pictures, getting witness statements to show that they were doing this. There was even one threat of violence against a customer, and even one other instance where they actually went inside the restaurant and were yelling and screaming and doing some pretty crazy stuff to try as part of their efforts. Now, of course, you may have a rogue picketer, or it may be all part of a bigger scheme of a union. You never know. But we filed a petition with the National Labor Relations Board to stop this activity because we believed it was beyond the powers that they were, or their rights under the National Labor Relations Act. Then one more story to tell you, as an extreme situation, but and this is somewhat folklore because it happened a long time ago, but sometimes unions can be difficult to work with for an employer. There may be bad blood between the employer and the union, which makes ongoing relations difficult. That's why having someone who has a lot of experience with unions and is good with labor relations and employee relations is very important. I know there's one organization, it was a car manufacturer in California. I think it was Ford, where they had a factory, and employee relations got worse and worse. Labor relations were horrible between the union employees and the company. I believe it got so bad that some of the union employees felt that they were invincible and were literally intentionally doing bad things to the cars before they left the plant, so that a customer buy a new car, it would be a lemon and would have problems right when they bought it off the lot. And it came to a point where the company felt like there was nothing they could do, and they just shut it down. They closed down the entire factory, which had millions of dollars of research and development placed into it, and just relocated it to a new location because the employee relations were so bad, because the union employees were not aligned with what the company needed to do, and in fact, in some instances, was sabotaging the company. And so that's an extreme situation of when union relations, labor relations, can get so bad where it literally causes the company to have to at least close doors to some respect. Okay, that's it for Chapter 5, talking about managing employee relations.